this. The housekeeping items that I have are for those of you that are participating online. I'm assuming that you can hear at this point. Please keep your mics muted, so we will mute mics if they become unmuted. Please do not use the chat function. If you need to make a comment or a call on by the chair or the panel, please raise your hand if you have a comment, and then we can also unmute at that point. Meetings recorded. Cameras are optional as we participate in this from the public side of things, but then also there is, I believe, a chance for public comment later in the meeting as well. So that's my housekeeping. For those of you that are here in the room, we do have restroom facilities right outside if need be during break time. So with that, I'll turn it over to you, Mr. Chair.
Thank you. I'll call the meeting to order. And Dale, can you take roll call, please?
Sure. Tommy Gifford.
Here.
Jeff Payton.
Here.
Brad.
Glad to just say I'm here and I don't have to say where I'm sitting it from. Time.
So now we move on to approval of the agenda, and I am looking for the agenda.
I'll move the agenda.
Second. Before we take a vote on that, I may have a comment or suggestion for the change of the agenda. And sorry, I just thought of this now. So when I was looking up at the board, I realized that we will have a public comment period, and that public comment period will happen after the deliberation of the panel. My suggestion, if we have a motion in a second, would be to insert between steps 4 and 5 that if either the state or the petitioner must add anything additional, that that's all.
I take that as a friendly amendment.
Second, all those in favor?
Aye.
Okay, we have an amendment adjustment of a step 4, which is applicants. So from approval of the agenda, we go on to approval of the minutes. We have a motion to approve the minutes.
So moved.
And a second, all those in favor? Aye. The ayes have it. So the minutes are approved. Now we move on to our new inserted agenda. First to the applicant. Is there any additional information that you would want to provide or comment? Keeping in mind.
Yes. So I guess what I would offer here is as we try to really understand all these parts that we're not very familiar with, 1, 3, 25, 404 rule, et cetera. There are a couple of things that come to our mind as we're going through this. And one of them is that it feels like that the Eagle office that we've been dealing with has moved the goalposts on us several times as we've gone through this process. The very first thing that we were communicated from the Eagle officer that's managing this case was that our submission or permit was administratively sufficient, but no precedence for a 5-foot dock. The first comment, and Bill Brown took notes during that phone call. We had subsequent phone calls. Again, it felt like the goalpost was moved, and it said, well, now you're interfering with the public trust in navigable waters. And so then that was what the issue was. And then we came to the meeting with you gentlemen, and then it seemed to be more about the marine impact and shading. And then it was, no, it's really more about you were deficient in your analysis of alternatives. So it seems like it for us on the outside looking at it feels like it has moved several times. And then according to Eagle's own policies, is that analysis of alternatives ought to be commensurate with the scale and the scope of the activities sought. So us doing what we're doing probably wouldn't have the same analysis of alternatives as someone like Barrett, or one of the other big marinas, commercial marinas. So I'd like for that to be considered as we're talking about this, and I'll reserve another 2 or 3 minutes when we get to 4.5 in the agenda to have another 2 minutes.
Thank you. Would anyone from the state like to add anything additional at this time?
No, no.
Okay, all right. From that, we'll move on to the next part of the agenda, which is the panel deliberation. And in this component of it, each of us can go through our analysis and our thoughts. And then from there, we'll have an open conversation between the panelists and see if that leads to a consistent recommendation that will come from the panel. If we do get to that point, then we will work at some drafting, some language for that recommendation that will move into the form.
Realize we're already at 4.5. Thought that was some sort of opening remark for me. I didn't realize, so I asked if I could have 30 more seconds to make 2 other points. I didn't realize we'd already got to 4.5.
Normally, we would have moved on, but since we're all new with this process, I want to make sure that the applicant feels that they've been able to do everything that they wanted before we get into our deliberation phase. So if we have a motion and a second to back up in the agenda to 4.5, we can consider that. All right, all in favor? Okay.
2 other comments here since before you get into your deliberation is that Rule 281.814 specifies a permit shall not be issued under the permit unless the department determines both of the following: the adverse impact to the public trust, riparian rights, and the environment will be minimal, and that it is feasible and prudent alternative is not available. Under Part 303, 281.922 defines feasible and prudent, meeting both of the following conditions. Both of the following conditions must be met. The alternative is available, capable of being done, taking into account cost, existing technology, and logistics, and that the alternative would have less impact on aquatic resources. So if the alternative doesn't provide a substantially greater, less impactful to the environment, then it can't be an alternative. It can't be a feasible and prudent alternative, because everything can be smaller. But if what the alternative is doesn't appreciably change the impact, then it by definition, by 303, cannot be a feasible and prudent alternative if there is no appreciable difference in the impact to what we're requesting. So those 2 rules go hand in glove about what has to be done, feasible and alternative, feasible and prudent, and then what the definition of feasible and prudent is. And I'll stop there.
All right, thank you very much for that comment. Now we'll move on to our deliberation. Jeff, do you want to kick us off?
I do. I did this to you in the last meeting too. I just want to make sure that this part of the deliberation, that we're clear that this is going to lead to further discussion between us.
Yes.
Because I've got as many questions as I have opinion for whatever's part of this deliberation, so hopefully this can be off very informal within the formal context of this meeting.
I would view that certainly the definition of deliberation is as we're exchanging information, that it may modify our opinions in order to reach a consensus.
Very good. Thank you. Now, is it appropriate for me to ask Mr. Reichel a couple of questions at this point?
Yes, through the chair, Mr. Reichel.
The applicant's representative has indicated through submittals that we got yesterday and this commentary today that continuing to reference Part 303, being the wetland protection statute. I was under the impression, perhaps wrongly, that this hearing was being held pursuant to Part 301. Part 303 wasn't necessarily applicable, while apparently there's some, because of the way that the Water Resources Commission administers their programs concurrently, that the whole idea of a feasible improvement alternative analysis kind of overlaps to some extent. Is it appropriate for us to be considering the Part 303 definition of what constitutes an alternatives analysis in our deliberations?
Well, let me first note that, my role here is to offer legal procedural advice, so certainly it's helpful to the team. But to the extent your question asks me to express an opinion on, I think, arguably, the substantive argument of the parties. In other words, I think your starting point for your analysis of this is, of course, both the survey, the information provided by the Department of Health, verbally and right. And to the extent that either party suggests that the outcome of the recommendation, that it's your view that the position involves consideration of 303, and I think it's appropriate. But, you raise an interesting question as to the extent to which the submission by the petitioner and their purpose staff have identified or suggested that Part 303 applies. My understanding, just looking at the record, that the application was submitted under Part 301. And I don't recall authority to engage in the use of regulated weapons. I'm comfortable offering my own conclusion as to whether or not it's right. Ask for, excuse me, an application is for. Again, I'm not telling you or the other panel members what to do, but I think it may be useful to get some clarification as to what the scope of the current is.
And have I heard the reason? Seems like, this simple situation. And it gets complicated when it may not be applicable to this. My understanding, which may be incorrect, is that the department suggested this needed to be looked at in a manner, because that's their context of reviewing applications in my experience. But my experience doesn't typically deal with just 301.
Yeah.
And so I see that playing out here where the department has suggested that there's a part of their an analysis of alternatives as is required under 303.
So,
Okay, then I want to discuss 303. That's what I'm hearing happening here. I'm wondering if it's, appropriate for us to be considering that, or, how seriously we do, or do we get into the weeds about it if 303 isn't the applicable statute? Because an applicant doesn't make the permit application under a certain statute, in my experience. They tell the department what the project is. And then the department then decides whether or not, is this a part 31, because it's a floodplain issue, is it part 301, because it's a ledge and stream issue, part 303, because it's wetland, or all three, for example. That's my. And so it gets to me to be kind of complicated and convoluted, and I don't want to drag us down a rabbit hole with you another one.
Yeah, understood. You know, this is sort of my interpretation, since includes if your wetland was included in the very beginning, when they're developing the site, because they were some type of wetlands. But that was at the beginning of, I think that's why that's mentioned and why it's mentioned. But that's where I think the confusion came from, was from the very beginning of the development process.
Oh, I would agree. I mean, we're working from the header pier out, so any wetlands involved are either on the peninsula or, you know, along the shore.
And when I looked at it as well, the fixed pier, because that was not being modified, that it didn't, the applicant was able to avoid the complexity of the application. And I looked at it as fortunate, historically, damage. It's, I think, would have always I didn't feel good.
I'm comfortable with that explanation and understanding of the panel. Is it inappropriate to ask Eagle their perspective on that? We've sort of heard the applicant's perspective on it, but under these circumstances, is it?
No, it's appropriate. So do we have a representative for the Eagle that would have a viewpoint on?
Yes, my name is Chris Kahn. I'm with Eagle Water Resources Division. So I've been following along the discussion as best I can. And I may have to defer to manager here as well, Luis Saldivia. But my understanding, my impression was whether or not a Part 303 should be considered in the criteria and the definitions for feasible and prudent alternative. I think what we would say is, you know, our understanding of this application, and I'm speaking a little bit now, you know, in terms of Bonnie, because it is the reviewer, you know, of the application, and she would be the one, you know, ultimately in her supervising the future permit, that would be the case. But you know, we determined that this project is regulated under Part 301 of the REPA. And so that statute and the associated administrative rules is the authority that we are looking at the application to ultimately make a determination on the application. Now, we did provide some guidance to the applicant recently, involved questions about, you know, what would constitute unacceptable, feasible, and alternative analysis. And in that correspondence, we noted that we do not have specific guidance under Part 301 with respect to feasible and prudent alternatives. So we did share an example guidance under Part 303 that speaks to what constitutes a feasible and prudent alternative analysis. But we provided that as an example and kind of guidance. But ultimately, our decision as to what constitutes an acceptable application, what can or cannot be permitted for this project will be part of it.
Is that good? And it doesn't answer your question.
Yeah.
Okay.
That being said, in the case, I do appreciate the effort that the applicant has gone through to document what they have deemed to be an analysis of their alternatives in this particular situation. So use of our panel and the commission on I'm used to supplying these alternatives analysis documents as a consultant to the department and having the department take months to review them. And in our situation, we get less than 24 hours to review them. And so I'm not feeling particularly comfortable about, as if we're in a position to even do this, render judgment as to whether or not this is an appropriate and valid response to a question, because it's thorough and it requires, it suggests, demands to me that we spend more time doing it if in fact we are supposed to be rendering some kind of opinion as to the thoroughness of this. And maybe that's not what we're here to do.
Yeah.
Maybe we're here to simply say that the process that we're engaged in is awkward and seemingly premature from my historical perspective. I know that's what the commission was, appointed to do, was to review applications while they're in process. But the kind of issues that are coming out here are the kind of issues that I'm used to presenting in front of a judge. Okay, if I'm an applicant or representing an applicant, we have our experts come forward and describe to the judge, testify, sworn testimony as to which are the facts. Okay, then the department does the same thing. Okay, and that's what a contested case is. And it's kind of like we're now being put in a position of, it seems to me, so hopefully you guys can correct me if I'm wrong here, in a position of kind of rendering some kind of odd judgment that typically is reserved for a hearings officer to rule on relative to the validity of the case. I mean, I noted in the previous submittal that the department was relying strangely on a report that had no particular reference to shading, even though one of the headings of the document said the effect of shading on the resources, it said nothing in that paragraph or two about what shading was. It talked about development along shorelines.
Correct.
And the negative impact of that. It was not something that wasn't quantifiable. It wasn't something that I've ever seen the department even use in something like a contested hearing. That's why when I was deliberating on this during our last meeting, I said, well, what does Fisheries Division say? Because these, or your aquatic biologist, the department's biologist, they're the ones that typically I'm used to seeing the department rely upon to make their case, to take the position that they're taking, that they don't want to issue a permit, or they're willing to issue a permit because they got an input from their from state of Michigan employees, not some, for lack of a better word, academic document.
So if I were to, I just want to backtrack so to make sure in my notes that I understand what you're saying, is that you, before I backtrack the issue on the shipment, I'd like to ask Mr. Reichel. So from what I understand, the role of a commission, we are not necessarily looking at administratively this process that the state will do in moving the application through. We are looking or identifying the specific issues that are in conflict and then giving our professional opinion in the form of a recommendation of resolving that technical.
That's correct. I think the statute is part of it, section 3. The decision on review of the purpose decision on a permit application, the position on a permit application before it is actually made a decision. I'm not here to criticize the legislature.
We're just trying to understand it,
Yeah.
so we move within it.
Exactly. And so I think, again, the statute doesn't have a great deal of detail, but I think what it says or contemplates is that in an instance such as this, the petitioner has raised concerns about what they understand the position the department has preliminarily taken on the pending permit application. This contemplates the process where petitioners' concerns and response from the staff and the respective positions of the parties at this stage are subject to review by the. And again, it doesn't offer a lot of specific guidance, as I think I indicated earlier. I think the statute contemplates that what you as panelists will look at the respective positions of the parties at this stage in the process and offer your recommendation to the director as to how this dispute at this stage should be resolved, recognizing that ultimately at the back end of this process, after you make a recommendation, the director will decide whether to accept your recommendation or to make some other decision. And what you're called upon to do, I think, is to look at the dispute within the framework of the statute that's involved, in this case, 301, associated with it, and then offer your recommendation as to the merits of the petitioner's contention versus the department's staff. And again, the statute says, shall make a recommendation regarding the petition, provide a notice to the director and the petition. The recommendation shall include specific rationale for the recommendation. The recommendation may be to adopt, modify, or reverse, in whole or in part, the department's position. So it's not very specific, but it contemplates, looking at the submissions of the parties within the context of the applicable law, and making a recommendation to the director as to whether she should accept, modify, or take a different position than what the staff has indicated so far.
So, Jeff, if I now repeat what I think I heard, so to make sure my notes are correct here, is that your concern is that conflict that you identified was conflict that would fit under the category of interfering with public trust, which leads to shading, which could cause some ecological damage. And that for you, that seemed to be a new and unusual argument used by the state. Is that correct?
I don't think so.
Okay, good.
You mean, are you saying a new argument in this case?
No, I think that's the primary argument in this case.
Yeah, right. So, no, I'm not suggesting that shading, if that's, I have heard of the department using shading as an adverse impact in the past. So
Yeah.
That part of your assumption, I would say, is not exactly in line with what I was asking. So, part of my confusion here, I guess. Hopefully you're getting some benefit.
It's your turn.
It's your turn. Going for it here. For better or worse, what is the department's position? Okay, I'm not sure what the department's position is.
Yeah.
The department has stated orally that they don't like the project, okay, and that they're probably going to deny it, I think. But we don't have a department position, I don't think, that I can necessarily respond directly to what Mr. Reichel just said our job is until we know what the department's position is. So help me maybe with that.
Okay, so I do believe into the record in our last meeting, their position.
Okay.
And I think part of this, I think it was called permit. Yeah, it even starts off, it starts the department position. So this document that I'm holding in my hands, the top of it says permit review, July 12, 2021. It begins, this is a part 301 inlands and streams application for widening of finger piers within an existing marina. So right there, the state is clarifying that the issue is, can you widen the piers? Then the next section in bold text is department position. And then although the department, although Eagle is not officially made a determination on the permit, so they haven't decided yet. At this point in time, the application does not adequately identify available alternatives. Additionally, based on what has been proposed, the adverse impacts to the public trust and the environment are more than minimal from the proposed project, and feasible and prudent alternatives are available. So that's where I was going. Is the adverse impacts to public trust, is that related to shading? And they move into, they go quite a list. So I agree. I think this was quite a bit of information to get to the one point that was in their third page, which was called excessive shading has a negative cascading. So they did provide their statement, and I probably should turn to the state and verify, is this indeed your position and statement of the document that I just referenced?
Yes, absolutely. The document, this is Chris Tom, again, from Water Resources Division. The document dated, I believe it should be July 12th, 2021. And there's headings there. First page being a permit review panel, partner position, the authority to review this application is evaluated under, and concluding with what we believe the issues are. And I think that would be the emphasis there, is what we believe unresolved issues to be. I think, correct me if I'm wrong, Louise, but I think our primary problem issue here is we think there are feasible improvement alternatives to the proposed project, and specifically the specific dock system that they're proposing. We think there's alternatives to that will minimize impacts to the resource. And based on what we've reviewed so far, we don't think it's demonstrated that there are not feasible improvement alternatives. So that is in fact the only alternative. Now, with that being said, there's this pretty long document that was submitted last night, 22-page document, and we have not fully evaluated that. We just haven't had the time to fully evaluate this and make a determination to the content of this document.
Good, thank you. So I have a suggestion. What if we hear evidence concerns? Because I really do think we got down to the essence. You're able, I have the same concern. Are we also considering wetlands? So you have this clarified, no, we're in 301. And you zeroed it right down to where I think the issue is with the state on the shading. Let's go to Evan and then we can circle back. That would be great. Okay.
Cool. No, good clarifiers. That beats it out a little bit for me. Well, yeah, I appreciate that Eagle may not have had a chance to look at the alternatives analysis, and I know that the alternatives analysis is a back and forth that can go on forever, right? Anybody can say, well, what about this? What about this? And at some point, how far do you stretch the feasible? You know, at the core, I think you've clarified what we need to be doing is talking about what are we, since there has not been a decision rendered, I guess we are recommending one of those. I guess it's not accept or modify or deny, but I think we're talking about deny or modify. Honestly, I think this situation overall on the recommendation side of things, I get the idea that we're talking about. I feel like the eagle position, let's say, is basically saying this is a tipping point. When I zoom out and look at the overall area, the scope and scale of human disturbance that's happened to date so far suggests to me that we maybe are past the tipping point. So I do believe I would recommend ultimately, and I'll give some logic, that this does not seem appropriate for a denial. They have gone through and provided alternatives analysis. I think you could say that's good enough, or you could say that's not good enough, depending on, your viewpoint and background. But I feel like the extent of what we're talking about is a real resource drain on Eagle, and maybe this wouldn't be the right case to make that kind of decision and get yourself into that morass, if you will, of what could potentially be a legal back and forth. So part of the recommendation is, let's say risk-based. What's the risk and what's the consequence here? But I would like to go just a little bit further into that. That prior permit that was issued, whole nother header dock and finger piers, and those were never put in. So, we were talking about square footage of shading or impact on the environment, but a whole nother pier was permitted at the time that would have those same impacts, if we're saying they are impacts that are significant or not. I'm not saying I can opine on that right this second, but that wasn't put in. What got put in instead was 7 or 8 individual finger piers. So what we're seeing is, I haven't done the math, and I don't know that getting into square footages when we're talking 0.010% here is really the right way to be going with pursuing both the intent and the specific language of the statute. So I appreciated Jeff's questions about, is it 301 or 303? What does 301 say about the alternatives analysis? So that's kind of one piece of it. I think it would be a tough row to hoe if you were, at least when I've been in front of a judge with things that I think are much more black and white than this, they have not been terribly sympathetic. So we're not in front of a judge. That's not where we're at. But my recommendation, again, would be just, even on that basis, this probably isn't the right case to go down that denial road. And then secondly, I feel like what we ended up with appears visually to be less square footage today, and it probably still will be, even if you have the 5-foot finger piers, than what was originally permitted, knowing that the folks on the southeast side of that peninsula that Bayou Meadows on went with just some individual finger piers. And those individual finger piers, right? I don't know if they're 3 feet or 4 feet, but when we look at these finger piers that are shared with 2 boats, really each slip owner is technically got 2.5 feet of finger pier, right? So what if you didn't have the header and you had individual piers out there that were 4-footers or 3-footers? I feel like this is being somewhat economical in that regard too, where again, you're splitting them. Now that's really common in that marina setting, whether you say a private setup that really isn't commercial as a marina or not. So I kind of think about that too. One other thing I think about is, I've got a 301 permit now where I'm being told we need to have more shading on that waterway. So here we're in a situation where it's more of an open area, and we're saying less shade is relevant. But again, I look at the applicant, and although they haven't made this argument, the reason I'm working on a permit where more shading is desired is for water temperature. So just like we could say, well, there's a tipping point and it's at 1/10,000th of a percent and you're adding that much shade, I think equally an applicant could argue, well, the shade is cooling the water in a disturbed environment to the extent of 1/10,000th of a percent. So I just feel like we're ending up talking about splitting some extremely fine hairs. And at the end of the day, if we then take the next step and say, well, does this set a precedent? I think we've talked about in the last hearing that each of these is individual and stands alone, but that precedent concern, I think, has to be there. If I'm in a regulatory role, when I'm in a regulatory role at my office, I'm always concerned about, is everybody going to want this, for the next one? So I do have a slight concern about that, but I don't think all those other docks, when you zoom out and look at the whole river, the whole Spring Lake area and all of that, I don't think you're gonna see a whole bunch of people tacking on an extra 1.5 or a foot or whatever to their dock. I just don't see that happening. So I see that you've still got individual cases and individual permits to deal with. So I just feel like we are really zeroed in on a very fine point, and I don't know if that's in the best interest of the department. Permitting this primarily because they were asked to do the alternatives analysis. They submitted one that does cover those areas of feasible and prudent, and whether we like it or dislike it, it appears that, you know, they have. Sorry, that was long-winded.
No,
I didn't pause as much as Jeff did.
No, that was very good. I think I'm gonna jump into my analysis of the situation as well. I think that we're gonna find that we all have common ground with what we're seeing here. In my analysis, I boiled it down to, I heard in the application that the applicant was primarily arguing safety, that they needed the 5-foot wide pier for safety. And that in reviewing the state's position, that their primary argument was the 5-foot wide pier created additional shading and that it would reduce biota and at risk potentially kill biota and in its decay pull oxygen out of the water. So if we take just a little bit of looking at a little bit of analogy for the record, the concern of why shading is an issue is the biota, because the plants that do live in that area, they, through photosynthesis, produce oxygen, and it's probably the biggest producer of oxygen for dissolved oxygen in that region of the lake, as opposed to the air, the atmosphere water interface. In our last meeting, I listened to some of the side comments about fishing that occurred, and when I heard carp, I became a little concerned that we had low dissolved oxygen, which is why I asked the state if they had any data on dissolved oxygen so we could see whether we're oligotrophic, mesotrophic. They don't have any information, but I do feel that we're probably in a mesotrophic to eutrophic stage, because the other comment on fishing is that there are panfish that they catch off the dock, which have a demand for higher dissolved oxygen. So to me, that's, and there's, you guys know there's so much more complexity with thermocline and turnover when we're trying to understand these things, and we're pulling back on our education and experience to fill in the gaps that we have, which when I was glad to see the effort on the feasibility study, but what I was hoping to see is if the argument of safety was put forth, that there was actually a calculation on what that pier weight could hold and what would be put on it. For instance, in our previous meeting, the concern was it was the weight of the ramp would make the pier unstable. Intuitively, it seemed like the bulk of the weight, that load would be held onto the fixed pier since that's what it was connected to. In the feasibility study, the concern is that 2 families would be on the pier at the same time. Again, but I don't see any, it was deficient in the math calculation on, is that really a valid concern? So in that sense, that was missing. The other part is knowing that the state's issue was shading and understanding that that shading relates to biota, which relates to dissolved oxygen. There's not anything in here that addresses that either. So it's kind of a good draft at a feasibility study, but it's got significant gaps. But it gave me good background on the whole story of how I got there. So from there, I then went to go look at the logic and the rationale for shading and the whole process of biota to dissolved oxygen production. And though I couldn't quantify those because there's not enough data available to do that, I could look at the main paper that was referenced in the state's position. And let's look at that again, excessive shading, and we see reference 3, 4, 5 several times the paper that was produced by Garrison in 2005. Garrison examined the effects of dock shading on macrophyte, macroinvertebrate, and fish communities in Wisconsin's lakes. They found that shading reduced abundance, which led to the corresponding reduction in macroinvertebrate numbers. To me, I'm more concerned about the actual plants. So we went back and looked at that paper. So when I went and I looked at that paper, and keep in mind that our debate now is between whether the dock width should be 40 inches or should be 60 inches, instead of between a 4-foot and a 5-foot width for the finger piers. And is that correct that you're, my question to the applicant, you're requesting a pier width of 5 feet?
That is correct.
Okay. So here's the Garrison, I'm looking today right now at the Garrison study from 2005, effects of pier shading on littoral zone habitat and communities in lakes Ripley and Rock Jefferson County, Wisconsin. They look at piers and they look at decks. They also looked at laterals, but piers and decks are relevant here. Average pier width was 4.3 feet, right smack in the middle of what we're trying to decide on. And that they give a square foot area for the decks. So the average deck, if I translate that into a square, is 13 feet by 13 feet. So this is actually relevant in the relative size of these two areas. The paper on lighting did state pier width also adversely affected light penetration, the wider piers allowing less light to reach the bottom lake. So that's inconsistent with the state's article or position. But when we get to page 13, the discussion section, so the end, when the authors or the researchers are wrapping up, they have in there, in our study, pier width and height above the water did not have a significant effect upon plant growth, nor did orientation. So ultimately, it's not sun penetration that would create the ecological decline, it would be plant growth. Plant death would consume dissolved oxygen. The lack of plants would produce less dissolved oxygen. So this study doesn't support the ecological concern that I think that the state is offering. And they go on to say that it's not the piers, again, at a 4.3 feet, that caused the problem, but what was causing the problem were the decks that were connected to the piers at approximately 13 feet by 13 feet. So the problem I had is that even the state's research that they're relying on didn't support that the wider decks were going to cause plant death. And part of my idea of the recommendation is, Evan, my recommendation is similar, but still giving the state, this is only one document, if there is something that is more precise, that shows that 5 feet or somehow does reduce biota, that could support their position. But the current research that they're citing doesn't support the position they was looking for. So despite the deficiencies in the feasibility analysis, with the point of conflict being that it would cause degradation of the environment, I don't see. You know what, we could take a break so that anyone needs to use the restroom, and I presume that we have a motion for a break. I'll second it, and ayes win.
Sure, I want to agree. I don't know if anybody's watching online, but.
How about 5 minutes?
All right, so we'll take a 5-minute break. I will mute the online folks during those 5 minutes and then turn it back on.
I think we're ready. We can call the meeting back to order. Where we had left off, we were still in our council panel deliberation. And I believe where I had left off was that the research that was cited in Griffin's 2005 identified that the decks of approximately 13 feet by 13 feet, that's an estimate based on square footage, presuming that they were square, was caused an adverse effect of biota, but the piers that averaged 4.3 feet in width did not. And the biota is the producer of oxygen, which would cause the ecological decline in that part of the lake. So to me, it seemed that that piece of research didn't support the argument of ecological decay, or I think it was public trust that it falls under. So I would add that within the recommendation that without additional supporting research that specifically addresses a width beyond 4.3, that the shading, that the decks and the reduced lighting and shading is not, there's no supporting evidence that it causes it. All right, Jeff, I told you we'd circle back to you.
Okay, thank you. Well, going in some reverse order here, what you just described to me is part of the problem where we are in the process. Because, and we haven't exactly had the department speak to this, so I'm going to throw my opinion out there as to what I think we see happen in situations where there's a disagreement between is that this request for the panel to convene is kind of sprung on the department during the review process, but that's, I guess, what's allowed by the legislature for it to be done. An applicant can say, hey, wait a minute, I think somebody else needs to intervene here to review this situation. I think it's not unusual for the department to rely on documents such as what they provided to us at that time or input that they've been able to receive from others as they were doing their review. Program, this is the time when you engage Fisheries Division to say, hey, you know, is this a legitimate, what, you know, because I'm thinking you're going to have to help us testify in a contested hearing if we're at loggerheads with the applicant. So an Eagle person typically goes to the DNR resource person and said, hey, comments from you on this. Whether there was a previous communication or not, it would appear as though there were no communications between Eagle and Fisheries Division DNR. Ironic and unusual that the applicant, sometime after the hearing, I guess, went. You got the comment that they supplied yesterday in their alternatives analysis that reportedly, I guess, third party, more or less, with no affidavit supporting it, DNR Fisheries Division said they were fine with this project. So there's a lot of unusual things going on here that don't typically happen in the course of the review of a permit application, in my experience. And I've done, you know, thousands of permit applications and not, you know, just not had the benefit, if we're going to call it that, of, you know, a panel getting intervening in the middle of it all. But all of that being said, so I sort of want to suggest that your critique of the department's document seems more than fair and appropriate. It's just that the department didn't take it any further. They were relying apparently on that kind of a document because that's what they supplied to us as being the basis for their apparent determination that there was an adverse impact on the resources, and this was their support of that. Kind of maybe a lightweight support, and maybe a document that somebody with some knowledge, which is why you're on the panel, would review and say, hey, maybe this didn't hit the mark. But usually they don't hit the mark until they issue the denial letter or they go to a contested case, in my experience. So I explained what I think might have happened. Unusual, but all of that being said, the applicant used at the beginning of this meeting was commensurate. And that is a significant part of what, in my experience, the department does on a daily, hourly basis, is determined on any given application. Is the documentation has been submitted or that they're requesting be submitted commensurate with the amount of impact? So when you have a dispute about whether there's even an impact at all, then I understand why that conflict then sort of drifts over into the question of alternatives analysis. What Evan was suggesting in terms of his recommendation, that this just doesn't seem, and pardon me if I'm mischaracterizing, Evan, please correct me if I'm wrong. This doesn't seem to rise to the level of the state expending any more resources on this project because of what appears to be a minimal impact in and of itself, notwithstanding the issue of precedence. And, if we permit this, then what can happen? See, can be in a position of determining and important for them to defend it based on that. Just think that what the applicant submitted yesterday is commensurate and beyond with the amount of impact that I'm thinking this project would create. So my inclination is to ask the department to review the alternatives analysis submitted yesterday with an eye towards issuing a permit that would allow the project to move forward based on this particular their review of this document. And if their conclusion remains the same after they reviewed it and given it that serious consideration, with our panel potentially suggesting that this impact does not appear to be warrant a denial from our perspective, so be it. They can go through that contested case process. Did I characterize what you said, Evan?
Very consistent and more eloquent.
Yeah.
I feel like a warm-up band.
Yeah. There's no way I could write that. I'm taking a moment to write down additional notes.
And I'm sympathetic to the idea. I mean, essentially, I feel like Eagle's position is, you can die by 1,000 cuts, right? And so, based on historically, I'm gathering that based on historically how these types of docks or what have you, marinas, whatever, have been permitted, that this is one of those 1,000 cuts. This is a step towards something that hasn't really been permitted before. That will be, I don't know if it's true statewide, but that's what I'm hearing and understanding. So I do respect that position. And again, as somebody who has a regulatory function in my job, I'm very sensitive to that. But I think you said commensurate. That was a very good word.
I don't even know how to write up the opinion on the process. we should.
I think our recommendation can stand just as this is what we recommend. I mean, we've got some discussion summary that maybe provides
So they,
some markers or yardsticks for it.
I believe they wanted us to say why. So that I started to jot down recommendation. First thing, the primary concern presented by Eagle was in the public trust, that the wider pier at 5 foot would damage biota of the lake, thus creating ecological damage. Eagle cites Garrison 2005 to support ecological damage. However, the Garrison paper does not support that a 5 foot wide pier would cause this damage. Rather, it is caused by larger platforms referred to as decks. Therefore, the research cited does not support damage. There has been no official input from departments such as fisheries. On that thing, your suggestion.
Yes, may I interrupt you for a second?
Yeah.
Going back to your comments and reviewing the applicant's submittal and how their alternatives analysis didn't hit the mark on a couple of things that you would have liked to have seen.
Yeah, I look at it as you go through iterations, like it's into a letter, hit A, B, C. So those were my,
So, you know, I'm trying to get both perspectives here and bring it somewhere in the middle, but I can tell you that if you want to call it a critique of your alternatives analysis, that went to safety, that could have gone further and would have been more helpful for it to have gone further because they're the only ones that really know that, or the dock company talks about that to some extent. If they wanted to take that further, that would have been helpful. Their response, though, didn't address this biota issue that you were talking about. That is not typical for an applicant to supply, and seldom is it required. Again, going back to the commensurate kind of thing. Usually an applicant just supplies, this is the project and here's why we want to do it and why we don't have an analysis alternative that's feasible or proven under the surface. And if we have experts and we are telling you that based on our expertise, whether they're the reviewer themselves or the people that they bring in, then document, hey, there's an adverse impact. So usually it's not the applicant that provides that sort of, as thorough of a document as you might like to think would be in an ideal situation, because applicants can be very simple, property owners are not sophisticated developers or companies that, have consultants that do those kind of reports. So that, I just throw what any of that commentary, but you don't normally see that in an alternative analysis. That's why when I read this, I thought, okay, it wanders a bit because they're not professionals at providing them, but it
good outline.
yeah, it's
They
pretty
had good, and I appreciated the historical background of how they got to where they were and the structure.
I got one more question maybe for Eagle. I didn't think I
Yes.
asked earlier, and you made it, you probably can't answer this quantitatively, but do many people ask for 5 foot wide docks? Do people ask for that and get rejected regularly? Or I just feel like everybody's working on a cost point and they want a dock and they want to get on their boat. And most people are like, what's the cheapest thing that gets me on my boat? So this gets to that death in 1,000 cuts thing. I don't know that we're really going to see everybody say, oh, great, now I can spend more money on dock.
We dig in here.
Yes.
One of the field operation managers for Eagle. Lakes Michigan and Superior. Just for context, briefly, I've been in the permit program for over 20 years. I was the supervisor for 20 years. And I was at the time the volume head of the regional permit was 30 places. For context, it was controversial at the time. I don't know. there was quite a bit of local concern with a couple of wetland groups at the time. Not sure if there's still in business, but so we went through some give and take with the local community, with the department, scope and understand. It wasn't just the dock, it was the development itself.
Yep.
We ended up with the permit that was issued in 2000 after, I totally don't remember, actually went through a contested case process which Jeff King mentioned before. In my own may not have, but the permit was issued for what we have and that we've seen. Marinas are different than your single-family residential property. So, but they're taking public trust waters, right? And we talked today quite a bit. Public trust waters for commercial, private use, which is converted that to some degree. We have, I think we heard some discussion about parrots. There's a large marina in Spring Lake. That went through a whole process of very legal process, went to court a couple times, going back, and so it's not unheard of when you have a marina owner and they want to construct or expand their facility. So a 4-foot figure, a main dock pier like we have here is not unheard of for a marina. 6, 8 foot provide access then to the finger piers. The 3 and 4 foot is depending on the body of water. Right? We have Spring Lake. It's a bigger water than if you're in a Midland Lake with no Great Lakes. We started to see this drowned river mouths situations like Spring Lake or White Lake, when you see like White Lake, to some degree where you have bigger fetches. The high water is controlled primarily by, in this case, Michigan, which we've seen in the last 2-3 years, right? And that's the reason why the docks were destroyed and on the water for so long. So, long story to get to the point. Generally, a 4-foot finger pier is what we see often for this type of facilities. A bigger head dock with a smaller finger pier to facilitate the access of their vessels. I wanted to say a couple of things.
No, that's good background.
No, so I know we talked and the chair talked quite a bit about the public trust, but when you look at the review of an application, in this case, and by the way, it is true, it is a truncated process that we're here today. We haven't really made a decision that would facilitate all the arguments that we end up doing in a more formal setting, as it is otherwise, where we can bring more testimony and more subject to cross-examination and the rest. But we're not there. So here we're making a sort of like subjective call to where we are. Generally speaking, and this is in 301, Lakes and Streams, we're going through that right now. That's the one subject to this application. So there's really 5 things the public trust is there. It's really important, right? The definitions are in the rules. The riparian rights, and I don't think there's a dispute here on riparian rights. They don't put the property, the dock, and the finger pier to be their own riparian area. Then there's the natural resource index, and I think the shading, to some degree, not only falls under the public trust, but also on the natural resource index, fish, wildlife, and that's all in section 30106 of the statute that talks. It says it begins the department shall not issue a permit unless. So it goes through the list of items that we have to consider, right? And then the rule 4. Rule 4 is really important because the applicant mentioned this morning that the department has to consider, again, that the adverse impacts to the public trust, riparian rights, and environment, that's what the natural resources business will be minimal. So we always try to minimize, that's what that means. Try to see, given two choices, what will be the less impactful alternative? That's number one, that's where the minimal comes in. And then the second piece of rule 4, that a feasible and green alternative is not good. And that's where we sort of are overheads at this point. So just to provide a.
Yeah.
So I really just wanted to ask that to just get a, you know, is Pandora's box going to be open? As an analogy, my community has been going back and forth on accessory dwelling units. You know, how can we do more affordable housing? Let people build a mother-in-law flat on the back of their property if they have room, if it fits into shape. And the argument against it is, oh my gosh, there's 21,000 parcels that technically we would be eligible for that. But you know, it's pretty clear that there aren't 21,000 people waiting to build those accessory dwelling units and so forth. So I was really just trying to get a sense of, you know, are we just going to see a flood of applications for 5-foot wide docks? And I'm not sensing that that's what the market is demanding, because people are determining themselves that it's not feasible and prudent for them to buy that extra foot of width. I feel like the 3 and 4 foot getting to your boat is sort of the gold standard that people go for.
And often, Chairman is right, there's a lot of, you know, the space is limited on those in a marina, okay? I would assume most marina operators, owners are trying to squeeze in safely as many boats as can possibly get into any given area. And taking away a couple of feet is an incentive in and of itself, I would think, in most situations, not have them build piers, finger piers, any wider than they have to facilitate the use of their marina. So that I don't see a lot of motivation between the cost factor and the space factor for it to really be an issue that would be raising its head very often in the department from payments kind of perspective. On a marina, I don't typically review marina applications to or assist in their preparation or permitting. So I don't know. It just seems to me like those are a couple of ways to typically want to build a bigger dock than they might otherwise.
So let's, because we're inserted in the middle of the process.
Yeah.
Main two arguments. One is 5 foot wide here provides greater buoyancy and safety. Yet for me, the manufacturer made 40-inch wide, the finger piers specifically for that. And the argument before was their engineering design calculations were altered because now you had a ramp, yet in a feasibility study presented, well, it could be 2 families. So I'm still struggling with that, and a viable alternative, I think a viable alternative is the bush. But on this hand, so the other side that's weighed against is the 5 foot is being denied because of environmental impacts, which when we begin to examine what those are, that has to do with the reduction of biota. So I really don't see actually the science and engineering support for your position. One, I don't see that a 5 foot wide dock would damage biota. And on the other hand, I don't see that a 40-inch wide pier isn't safe. So that puts us in this quandary of our recommendation. So we're doing a recommendation to the state. So we could recommend that there the recommendation that it be approved if the only concern is ecological damage and we're relying upon the data that has been provided us so far? But if they use ecological or environmental damage, that additional information would be needed, whether it be from research, actual data, collected, or from a
Like reaction, you ready to it? I mean,
I'm trying to get to how we can craft this so that it helps the process, but it also gives an opinion that we don't really see the additional with, you know, as a prospect.
Yeah. No, I hear what you're saying. I feel like that's been captured in our discussion and we're just issuing a recommendation. So Eagle can do what they like with our recommendations. It's not like Eagle asked us for our recommendation. The applicant asked us for our recommendation too, right? So I feel like it can stand alone and quite honestly, again, in the world of sales, they say no is the second best answer you can get and maybe is the worst answer. So if we issue something and we say, well, maybe if you spend more time on this and that, and I think Jeff and I have already kind of gotten to the point of, is this the right thing to be spending, valuable permitting resources on? And have that discussion about, yeah, but what if this becomes the new standard? We seem to convince ourselves that we don't feel like that sets a precedent, but Eagle would know better than us too. So I feel like we might just saying we would recommend issuance of a permit based on the discussion today, based on the body of the discussion. So I'll go ahead and make that motion. We don't have to act on it, but just to have it on the floor. So we're discussing what we do or don't like about having a motion to simply recommend approval of permit.
Second.
I second.
All in favor?
We don't have to vote if you want to have more discussion, Tony. I wanted to just make sure it was on the floor.
No, I'm in agreement with it. Where I'm struggling is getting the right words.
Yes, understood.
So the overall that we're all I feel that we're all recommending that they approve it based on that we don't see the additional with cost.
Yeah, at the end of the day, I mean, I go back to the aerial where it's got the red box around the pier, and that's where the public trust and the environmental impact is. It's already there. The trust is already impacted and permitted, and they're not going outside the box. That box is still the same box. So for me, that's where I get to the word minimal, quite honestly.
So we could use the words of recommendation.
Yes.
We recommend.
You tell me?
Yes.
Sure.
I'm sorry to interrupt, but just to reiterate, as you're discussing and deliberating what your recommendations may be, that will remind you, very specific, but it says, the recommendation shall include the specific rationale.
Oh, yeah, no, we'll do that. And that's what I was getting to. So we're going to start off with a simple comment of we recommend approval. And then we'll go, we recommend approval for the following reasons.
Yeah, absolutely. I just didn't want to get into, it's sort of approved, but if you do this, and that, yes, that's implied when you say what's the basis of that recommendation.
And I'll narrow our approval to 5 foot wide fingered piers. So if there's any other issues, we haven't been asked to discuss that.
Up to 5 foot, just in case. I'd hate to be back for that. We found a 47 incher. Thanks, Bob.
Mr. Tagline, turning it down just to confirm the motion, it's to approve the permit of the 5 foot wide. Was that the motion?
That is the amendment motion.
Yes. Could you read that again?
So what I have, please correct me if I'm wrong, to approve the permit up to 5 foot wide finger piers. And I have you making the motion and Mr. King seconding it. Or is that?
I would actually say table that motion right now, don't
Okay.
delete it.
Okay.
Simply because I think we're going to expand because we're gonna give reasons 1, 2, 3, and 4, and that way we'll do it all in one motion.
Okay, sounds good. I will pause.
Department of Natural Resources, Fisheries. Public notices issued. They get a copy.
So,
You go there, can I ask a process questions? In this recommendation that we make, it's simply a recommendation that goes to the director. That recommendation. Is a decision to make a recommendation. May or may not be approved, or
Absolutely correct. The way the statute's written, goes to the director, and then she has, I believe, 60 days.
So-
after.
right, and I just so.
Concerned that with the specificity we're providing, that we might end up with what we didn't mention. But that wasn't listed, and now there's leeway
Yes.
because it's informal, right?
Yes, yes. And
Good
it's,
point.
it's reasonable for us to put down the thoughts that we have today based on the review that we've done to date.
Right.
It's just the process isn't done yet.
Yes.
You know, so this gets to be a governmental thing that I'd like to put,
Yeah.
you know.
Including but not limited to.
Yeah, so it's just, you know, this process could go on, and to the extent that we can help expedite it by making our recommendations and allow the parties to resolve this, in whatever manner they come to. You know.
I'm not legal in Delaware, Maryland, or Hawaii.
So this is for my colleagues, as opposed to making a motion yet. And approval of up to 5-foot wide finger piers for the following reason. 1, Eagle presented a concern of damage to the environment caused by excessive shading. This was supported by Garrison 2005. However, Garrison 2005 studied piers averaging 4.3 feet and found no damage to plant life. Parens, see discussion section in Garrison. Information was provided, such as comments by DNR, actual data collected, or other research. 3, the area of the piers does not extend beyond the area of the original. Just trying to keep it simplified.
Yep.
But yet give concrete reasons for our logic.
Last one, again.
Number 3,
Yes.
the area of the piers does not extend beyond the area. I think what Evan, and how we don't grasp it, this is that the original permit.
Because I think you also were capturing, when you say the area, there's a geographical area within the red block, so to speak, on one of the graphics that were presented.
Should I change?
There's also, excuse me one second, there's also the area of dockage that would have additionally shaded the bottom land that appears to be impacted to some extent by the proposed pier, the additional width of the pier being the issue at hand. So I think we've been presented documentation that it's smaller area of pier coverage than what was permitted, but also a smaller geographical area of public trust taken up, I think. Question, but there's two different kinds
It appears
that covers it, I guess.
is smaller than the area. I'm still not distinguishing between, see, the part that I hesitate on saying that the square footage of, when you really look at the paper, it's not a function of damage, is because they were much wider, they were 13 feet wide. So they do have a point, that there is a point at which the width of the structure that's on the water will kill the item. It just doesn't support 5 feet as a look that way. But it supports 10 feet.
I appreciate that.
So I was trying to keep it as within that box as opposed to. Any suggested clarification on item 2?
Just to suggest on that, again, if we look at just this pier with these, or this header pier, just what's being modified, the area would be greater than what was originally permitted. I was just saying a whole nother one about the size was permitted in another spot. So I think if we try to explain it further, all we do is make it more confusing. I like the way you left it.
Okay.
I do feel like that, I guess it's captured in our discussion that we kind of talked about, the notion that the information in front of us has led us to believe that the impact is minimal. These details, I guess, help provide a little bit of wiggle room for Eagle, but I think another go-round in the alternatives analysis would make that more clear, or you get really is tough to say that this is what. I think that's captured there, that was in our discussion, so.
All right.
With that, I would be comfortable with making the motion.
I'll read this in as a motion. And then after I read it in, we'll second, and then. Are you ready, Dale?
I am.
Okay. We recommend approval of up to 5 feet wide finger piers for the following reasons. 1, Eagle presented a concern of damage to the environment caused by excessive shading. This was supported by Garrison 2005. However, Garrison 2005 study here is averaging 4.3 feet and found no damage to plant life. Then in parentheses, see the discussion section in Garrison 2005. 2, no additional information was provided, such as comments by DNR, actual collected data, or other research. 3, the area of the piers does not extend beyond the area of the original permit. Okay. Second. All those in favor? Aye. Looks like that, or we do have to do individual votes on the vote.
No, that's fine. And the record should reflect that each of people voted in favor.
Okay. Okay, so now, Evan has notes jotted down. We've done these by hand. I wrote the motion down that we could attach to this. Is that sufficient in how we submit our documentation? Which is very uncomfortable for the 3 of us, not to have it go through a technical writer peer review, but
So I think,
what's in the record?
correct me if I'm wrong, Bob, but you can go ahead and type up what you would like, because the motion, as long as the motion is the same as what we just approved here, you can go ahead and type it up on that form that was provided, and the 3 of you can finalize it, send it to me, and I'll send it to each of you to add any notes or critiques, and then once we have the final document, it'll be some time. How does that work?
Right,
Is that-
this is not enough room, so what I'm gonna suggest to the panel is Evan, type up the notes, since he did a good job of taking them. I'll type up the motion, and then,
We can consolidate it and get it on the form.
Yeah.
As long as it's representative of what we did today. Is that okay?
Yes, just so I understand.
Yeah.
So the plan is simply to type up the motion that the panel just unanimously did,
Yes,
and then attach that to a form that would be transmitted to the director and
Yeah, so we actually
the
have,
petitioner in embodying your recommendation.
okay.
so administratively, I'll facilitate that process until we have a final document. And then that final document will be sent to all parties, including the director.
So,
So does that work? As long as it's based off of the motion.
Yeah, I mean, it seems pretty straightforward. I think somebody should just type up
Yeah.
the content of the recommendation in the motion that was approved. Just type that up and hand that to a form. I haven't done these. You use a form, does it use?
Dale, what if we were to give you our notes? You typed them up since you're kind of the neutral party in this. It comes to the 3 of us look at it and we say, okay, that's what we said.
Am I gonna be able to read your handwriting?
I think so. I think it's all legible.
I actually don't want to mistake anything
That's
that you
fine.
have in here.
Just give me a fillable form, a Word document, or a fillable PDF, and I'll just go ahead and bring it out.
So, yeah, after the meeting, I'll go ahead and electronically send to you the form. Go ahead and type in the form, how you would like to present it, and I'll make sure all three of you agree on the final version.
So, and just to clarify, Bob, once I get this typed up, I should send it to Dale, and then she would send it to the panel for feedback? Is that the best way to do that?
Sense,
Yeah.
if I understand Bill correctly, just so I'm clear. all right. So, Evan, what are you typing, what are your notes?
There's a form that says Environmental Permit Review Panel, and it's a meeting summary and recommendations form, so I'm gonna type up the basics of what I know about who was here, but the summary of our discussion, so I took notes about the individual comments, not detailed verbatim transcript, but notes of what each person said, and then the panel recommendation that Tony wrote down, so those two boxes are, looks like what we want to have documented in the record.
And when I send you that form, I'll have the top part all filled out for you.
Oh, bless you.
So meeting summary and writing.
Correct.
Would it be more efficient for Tony and I to review his notes now before they go to her, so it's more done in the open meeting setting than otherwise? Because it seems it's kind of odd that we're, because once we start making comments, I know it's subject to FOIA, but I don't, you tell us what's, all of a sudden we seem to have gone under the hole if we're not supposed to be under.
Jeff, I read it, so that's why I was good with what he wrote out.
I added one more paragraph, you might want to read that last paragraph, just to be sure, because it's what you said.
Okay. 20th and he's.
Okay, fair enough, that just,
Yeah,
the discussion can continue, I'll just take a couple minutes.
you might be able to recess. I don't know if we have more to discuss.
Well, we have a couple other agenda
Oh,
items,
housekeeping.
so we can move on to that. And now's our opportunity for public comment. In public comment, again, we had talked earlier about procedure that we would hold any individual public comment to 3 minutes. So at this time, we'll open up to public comment.
Okay, so I will start with in-person participants. So anybody in the room want to do a public comment? Okay.
Thank you for your time.
And then anybody online or on the phone wish to make a comment, you can go ahead and unmute yourself right now. All right. I do not see anybody raising their hands or unmuting their phone. So I'm going to conclude that we do not have any public comments.
Thank you. Before we go to adjournment, I do want to thank everybody. This is a new process for all of us. Robert, you've been very helpful in the procedure, both the applicant and the state. We're also trying to find that path for us to Dale, good job, we're doing something. It's like herding cats. So,
Mr. Chair, before you adjourn, just following up on Jeff's comment, you've indicated, Evan, you've looked at the draft meeting summary. You have Chair, Jeff is looking at it now. I think before you close the meeting, you should memorialize that.
okay.
By the way, housekeeping item, or hindsight's always 2020 item. Maybe next time we have, okay, we're gonna have the next meeting, we might go ahead and establish a deadline for submittals, just so there's clarity on that. I know that I was caught a little short, but yeah, I don't really keep regular work hours and then a billion night meetings, so it sounds like you read that stuff at night. But I don't think we should expect that the staff, as overwhelmed as they've been for 2 years with this, should be expected to receive documents 5 the night before. So that's on us that we did not specify a deadline prior to this meeting. Duly noted.
Yeah.
Remind the next group, if it's not one of us, I'm pretty sure I'll remember to get that one in there.
Mr. Press.
Okay. You want a motion to
Yeah,
do what?
accept that, how about if we take that, you agree with Mr. Pratt's to a motion?
I make a motion that we accept Mr. Pratt's notes.
Second that.
Instead of discussion during the meeting, summarizing it accurately.
I second that. All those in favor? Aye. Aye. Ayes have it. All right, with that, do we have a motion for adjournment? All those in favor? Aye.
All those opposed are welcome to sit in the room until they decide to get up and leave. Somebody said that on a Zoom call the other day. Welcome to stay on the call. We won't be here.
Chair's approved.
I was on the call, by the way. I can't read those.
There's one.
You know what, considering.
Just no numbers, do we have